And this is where we start this evening. The Constitutional Court has dismissed Public Protector Advocate Busisiwe Mkhwebane's attempt to appeal the scathing judgment that invalidated her report on the Gupta-linked Estina Dairy Project. The Apex Court found that an appeal would have no reasonable prospects of success. The High Court in Pretoria had previously found that Advocate Mkhwebane had failed in her duties to investigate the matter. Senior legal journalist Karyn Maughan joins me now live. Karyn, a very good evening to you. I think we need to look at these Estina rulings and how they could potentially be problematic for the Public Protector in light of the impeachment investigation. How significant are they?
Well, it goes beyond the fact that Judge Ronald Tolme ordered that Busisiwe Mkhwebane must pay 7.5% of the legal costs of the DA and CASAC in challenging her Estina report on the basis that it was essentially a whitewash. That report forms a pivotal part, Griselda, of the DA's motion to have Busisiwe Mkhwebane face an impeachment inquiry, together with the South African Reserve Bank judgment that the Constitutional Court handed down, in which it found and supported the Pretoria High Court's decision to impose a personal costs order on Busisiwe Mkhwebane. And again, both of these judgments being shaped in different ways by this perspective of the courts that Busisiwe Mkhwebane did not understand the constitutional mandate of her position, and it also displayed bias in the direction of SARB, of course, against the Reserve Bank and in favor of illustrated with so-called secret meetings with the State Security Agency and presidency. But in the Estina matter, really this deep unhappiness over the fact that she had failed so substantively to investigate senior ANC leaders, Ace Magashule and Mosebenzi Zwane, over their alleged involvement in the dairy farm scam.
Karyn, what did the court say in reaching its decision? And is this way now clear to prosecute those involved in the failed project?
Well, essentially, the court didn't even entertain a hearing, which is really, in many respects, Griselda, the ultimate legal diss. I mean, essentially, it looked at the papers, the application that she brought, and said, we don't think you have a chance of even persuading us on the merits of this application, and so we will dismiss it. But what it does mean, we know the NPA has been looking at potentially reinstating the Estina Dairy Project charges, which of course were aborted in a highly embarrassing way for the NPA a few years ago. And they are talking about possible prosecution and possible extradition proceedings against certain individuals that they have not identified. But more problematically for Mkhwebane, this essentially paves the way for that judgment to be used in its full force if and when she faces an impeachment inquiry. Of course, at this point, she is challenging or seeking to interdict that inquiry from proceeding, pending her substantive challenge to its rules.
The Public Protector has applied to the Constitutional Court in two other pivotal cases, Karyn, for which she was granted a hearing. That's SARS and Bosasa. Those are both being heard in September, right?
Correct. And I mean, I think that's an important situation to emphasize. Remember, in those instances, the High Court both denying her leave to appeal to those particular rulings. One centers on her argument that SARS must be compelled to hand over the former president's tax records. The court found against her. And of course, that highly politicized Bosasa matter, in which the report that she did into President Cyril Ramaphosa's CR17 campaign funding was invalidated. Of course, Ramaphosa arguing to the Constitutional Court that it should do what it's done in this particular matter and dismiss that case with costs. It did not do so. Both of those hearings proceeding on next week and on the 29th of September.
Karyn, thanks very much indeed for your time this evening. Senior legal journalist Karyn Maughan.